Lady from North Carolina is recognized.
Thank you, Mr. Speaker. Mr. Speaker, my colleague from Colorado knows very well that the House is doing its work and focusing on the things that are important to hardworking Americans. Just this week, we're holding 81 hearings here in the House in various committees. That is definitely doing our work. We're here on the floor today looking at a very important piece of work and overriding this onerous rule that is not a waste of time. Mr. Speaker, the National Labor Relations Board has been attempting for years to tip the scales toward union organizers, and last December they were finally able to accomplish one of their major goals with approval of this ambush election rule. The two board members who dissented from the decision were clear about the rule's primary purpose, enabling initial union representation elections to occur as soon as possible. This rule will shorten the length of time in which such an election is held from the current median of 38 days to as little as 11 days. The board's decision was broad and unprecedented, overturning decades of practice in labor laws and skewing elections in favor of unions. One of its most outrageous provisions is postponing decisions about who is eligible to participate in an election to after the election. One of the most fundamental principles of a fair election is ensuring only those eligible to vote to have the ability to vote, maintaining the value of each voter's individual vote. That basic democratic protection would be shattered by this rule. It may also lead to more union representation elections being set aside and new elections being ordered. Glenn Taubman characterized the consequence of this ambush election rule very fittingly in testimony before our subcommittee on health, employment, labor, and pensions, saying, quote, "It's akin to a mayoral election in which it is unknown either before or after the election whether up to 20% of the potential voters are inside or outside the city limits," end quote. The rule will also require a new mandatory poster be placed in the workplace within 2 business days of receiving a petition for election, the content of which will be determined by the National Labor Relations Board. Employers are also provided only 8 days to find experienced representation before facing a hearing and must file an in-depth statement of position within only 7 days of receiving a petition for election. Companies of any size, and in particular small businesses, frequently do not have in-house counsel and are not prepared at the drop of a hat to respond to complex, consequential legal situations. A provision with a serious impact on employee privacy is the access provided to unions of additional contact information, including every employee's name, address, personal phone number, and personal email address, which must be provided within 2 days of an election order without any option to opt out. Important review procedures would be set aside by this rule as well, including the opportunity for review of decisions made prior to the election by the board itself. The board's requirement for review of post-election disputes would be made discretionary for the first time as well, limiting oversight. This flawed decision is currently facing litigation from the private sector as well, with the U.S. Chamber of Commerce and other trade associations filing a lawsuit to block its implementation as a violation of the National Labor Relations Act, Administrative Procedures Act, and employers' rights. I urge my colleagues to support the rule and the underlying resolution and reserve the balance of my